What's up everyone, it's the Law School Lumberjack. Today I'm here with another video. I apologize, my apartment is scorching hot right now, so if I'm sweating, I apologize. I hope it's not too distracting, but it is very warm in here. So moving forward, we are going to be talking about the doctrine of duress. Now, this is one of those doctrines that, if you saw my previous videos on, void ab initio versus voidable contracts, in the modern cases, it is likely that duress will lead to what's called a voidable contract, which means two things. Firstly, it's only the party who is vulnerable or taken advantage of who can challenge the contract under the doctrine of duress. Secondly, the contract in and of itself is not void until the court declares that that contract is void. So the ramifications of that, if you watch my previous video on void ab initio versus voidable contracts, the ramifications of that will be clarified in that video. But essentially those are the two important distinctions as to why whether or not duress leads to a void ab initio versus voidable contract matters. So just think, in modern case law, duress, usually voidable contract. Let's talk about the general status of contract law and then how duress fits in there. So as a general rule, people who enter into contracts are assumed to be bound by those contracts. Now, one of the axioms that isn't really stated in the 7 elements of the contract, but one of the axioms with respect to contract law is both parties entered into that contract out of their free will. So when you have a situation where the circumstances surrounding the contract, maybe the negotiations, whatever it might be, when the circumstances surrounding that contract are such that one party didn't have free will, or their free will was, arguably lost, the courts have stepped in and said, then we might not hold that contract to be enforceable. That's what we see in the case of the Doctrine of Duress. We also see that in the Doctrine of Undue Influence and Unconscionability. If you want to see those videos, please check my channel, as I've made videos on those as well. So I'm going to give a kind of a brief journey of economic duress, and the reason is because compared to unconscionability and undue influence, which have very clear tests, the test for economic duress, especially when it comes to Canadian case law, is not extremely clear, especially with what you're taught in law school. So basically, let's kind of go through how the UK handled things, and then we'll kind of go to Greater Fredericton Airport and NAV Canada, which is one of the predominant cases that law schools look to when studying economic duress. So back in the UK, when contract law was kind of being formed, we had a situation where economic duress wasn't a thing, right? We had a case where you could have duress through threat to a person, or duress through threat to property or goods, right? And those were legitimate forms of duress that could vitiate a contract and have it being found unenforceable. But until relatively recently, there was not economic duress. So if there was pure economic loss or the threat of pure economic loss, the court wouldn't hold a contract to be unenforceable on those grounds. Now, in comes a case from the UK House of Lords called Pow On. And this was the first case to establish economic duress. And what that case essentially did was it didn't create a test in the sense that you had to check a bunch of boxes. It created a set of factors to consider whether or not economic duress played a role in the formation of the contract. So, the factors were, was there an economic threat? If there wasn't, clearly there was no economic duress. Secondly, did the party agree to the contract but protest? So if a party acquiesces or signs a contract willingly, it's less likely in those circumstances that that party was, truly under duress. Thirdly, was there an alternative course of action? Now, to me, this factor especially makes a lot of sense, because if there was an alternative course of action and the party still decided to go with the improvident deal, or the allegedly improvident deal, well, then they probably made that deal out of their own free will. So, it's less likely that if there was an alternative action, that the vulnerable party's free will would have been vitiated. Fourthly, was the party independently advised? So were they represented by counsel or a lawyer? And fifthly, once the contract was in place, did the party repudiate that contract or try to repudiate that contract in a timely manner? So this factor also makes a lot of sense to me, because in a situation where if a party is getting the benefit from a contract for 10, 15 years, it's less likely that there was true economic duress compared to a party who, as soon as they have the money to go to court, or as soon as they are able to repudiate that contract, do so, then it's more likely that they were facing true economic duress. That's how England or the UK dealt with it. And now that doctrine applies in Canada, but we get Greater Fredericton and NAVCAN. So in that case, what the court essentially does is they look more towards the pressure rather than the bargain itself. And there's a lot of academic commentary on whether or not this is correct and whether or not this is good law, but essentially, to some extent this makes sense because the pressure itself would arguably vitiate free will. But I'm not here to provide any academic commentary. I'm just here to provide the straight test to help you on your law school exams. So in Greater Fredericton Airport, the test for economic duress is essentially there's two threshold requirements that have to be met. So firstly, the promise has to be extracted through pressure. So you can't have a situation where there's no pressure and a party just freely enters into a contract. The second is that the pressure had to be such that the party had no other alternative. So the pressure had to be so bad that the other party was basically forced into the contract. So if you meet those two threshold requirements, you move on to the next step. If met, then the court has discretion to consider whether or not the contract should be unenforceable on the grounds of economic duress. And there's kind of three factors that the courts can look at. Well, the first thing that the court can look at is, was the promise or was the contract properly supported by consideration? Secondly, the court can look at whether or not the party was coerced or did so under protest. So again, taking from Powon, if a party did not protest as much, then the court can look to that and say, it wasn't economic duress, or it's less likely it was economic duress. And thirdly, the court can factor in whether or not the party, within a reasonable time after the contract was formed, took steps to disaffirm or repudiate the contract. So in those circumstances, the courts can take all those factors and the fact scenario involved and consider whether or not the contract will be held to be unenforceable on the grounds of economic duress. So being the pragmatic law student you're probably wondering, how do I apply this on the law school exam? So there's essentially two cases that can apply on a law school exam. You can have Powon and you can have Greater Fredericton Airport. So you probably want to reference both of those cases. And you probably want to use the factors in Powon to kind of initially decide whether or not economic duress is possible in the circumstance, or a claim for economic duress is possible. So what you want to do is consider, is there a situation where a party clearly was taken advantage of because they were in a bad financial spot? And if that's the case, then you might want to consider the factors in Powon to decide whether or not a claim for economic duress is possible. Now, if you need to use NAVCAN as well, maybe the actual bargain itself wasn't that bad, but pressure was very bad. You probably also want to reference the Greater Fredericton Airport and NAVCAN case to suggest that the pressure was such that the contract should be unenforceable on the grounds of economic duress. So the facts you're going to want to look at to consider whether you should even consider economic duress are things like, is there an inequality of bargaining power? Is a party really, really strapped for money, and is there a really bad economic fear from that party's mind? Is the party who is not vulnerable taking advantage of the vulnerable party? So if you have a situation where a party is desperate and a non-vulnerable party takes advantage of that vulnerable party to make an improvident deal, then you might be thinking, okay, this might be economic duress. So those kind of factors will probably raise the flag telling you, okay, that might be economic duress. And then you can apply Powon and Greater Fredericton Airport and NAVCAN to decide whether or not the claim for economic duress is actually a legitimate one. In any event, I hope this is helpful. If this video was, I'd really appreciate it if you could like and subscribe. Take care. See you next time.